Good evening. This is Rahul Reddy live here from Houston, Texas. Every Tuesday at 5 p.m. Central Time, Reddy Neumann PC does bring in immigration updates. Emily, right now it seems that the Biden administration is going to come into power on January 20th. Right now we are November 17th. So there's still 2 months left out for the Trump administration. I've already noticed that there are some policy changes that he's bringing in. What damages can Trump administration do? According to Trump, the colored immigrants are drug dealers, rapists, murderers, and that's the intention that he has on these people. And now he's bringing all these last-minute changes. What can he do in these 20 days? What more damage can he do?
Yeah, he's definitely not stopping anything that he's already put into motion. So we've got new regulations that are proposed and being finalized, particularly the F1 students eliminating duration of status. We've got a new H-1B regulation that's set to take effect next month. And on top of that, the things that he can do even more easily than a regulation are policy manual updates. And I think we've gotten 3 new updates just within the past week. So he's definitely
Are there
moving
anything
forward
good
with those.
for
No,
the immigrant?
of course, none of them are beneficial to immigrants. They're all ways that we can make it more difficult or ways that we can deny more applications. So there's plenty that he can do and is expected to do, and all of this is so that when the Biden administration comes in, they're going to be busy trying to figure out how to undo all these things rather than focusing on their own agenda and trying to actually make improvements to immigration. They're going to be too busy trying to undo all of this. So it is a way of slowing down the new administration's agenda. It is something that most presidents do at the end of their term when the other party's getting ready to take control. So it's not particularly something only Trump is doing. But
most of the administration that I've seen, Emily, whether it's Clinton, whether it's Bush, especially I didn't see Bush doing much damage. I've seen Clinton doing a lot of damage, and also Obama. They didn't focus on the immigrants though. They were more about the environmental regulations, things especially not related to immigration though. This is the first administration past 25 years that I'm watching in where the guy is focused on the immigrants more than anything else.
Yeah,
I don't know about the other
ran
things.
on,
I'm sorry?
That was his campaign.
That was his campaign all along. Now, Emily, there are some changes that you pointed out that I want to identify the people is that the H-1B regulation with regards to the specialty occupation is becoming effective on December 8th. So it's a more stricter interpretation of specialty occupation. Do expect more RFEs. So if you can file your application before December 8th, any extensions, amendments, please file it before December 8th. The second thing is that if you are working for a consulting company, after the agreement between the IT Serve and the USCIS, because of the court litigation, we've been getting 3-year H-1B approvals pretty frequently. Very rarely we see any 1-year approvals anymore. But starting from December 8th of 2020 though, because of the new regulations becoming effective, you will get a short-term H-1B approval. So please try to file your application if you can before December 8th. And you pointed out on the duration of status on F1. Is it becoming effective or can it become effective soon, the particular thing?
So that one is a proposed regulation. The commenting period, I believe, has ended. So we could see a final regulation come out before January 20th.
So if that goes into effect, the way the proposal is that every time the student changes from one university to another university, they have to file an I-539 application, have to go through biometrics. And the processing time for those, it seems to be, in the California Service Center is approximately 20 months right now. It used to be 8 months 6 months ago, and now it's 20 months. That's one thing. And if there's another problem we have is that when they graduate, Emily, they apply for the OPT though. Previously, they don't have to do anything. They will apply for a 765 application with the USCIS, which is taking a little bit longer time than usual though. Now, are you telling that they have to file a I-539, and it may take up to 20 months for them to get it.
Yeah, same for the STEM extension. Same if you just want to delay your graduation date. Right now, you just go to your school and get an updated I-20 that changes your end date for your program. Going forward, I think it's
So
going to
even
require
this
filing.
can come into picture before this administration leaves. And I just want to point out that Obama administration has done some regulations, especially the H-4 EAD, which allowed people to get an EAD if the spouse has an I-140 approval, and there are some other exceptions that are there where people can get a H-4 EAD. Now, Trump administration wanted to undo the H-4 EAD because of all the legalities and the things that are surrounding it. He couldn't do it. He wanted to propose it. He didn't propose any regulations on the H-4 EAD, and now he's going out of power. Now, what I mean to say here is that if the administration wants to undo some of the regulations, though, it is very hard for them to undo those things. It's not that easy. So when Joe Biden administration comes into power on January 20th, though, don't expect he can just undo everything. Also, on the policy memorandums, the policy manuals, Emily, these are the policy manuals that the immigration officers have to go through those things. When they adjudicate the applications, they will go into the policy manual and they normally follow the policy manual. Now, we have just seen an update on the adjustment of status that if a person moves from one company to another company about after 180 days. Now, what update has he done right now?
So yeah, they did announce a policy update regarding AC-21 portability for when you're eligible to move your green card process with you to the new employer. It's quite long and detailed with a lot of different examples and scenarios of what about situations where the job changes due to career progression. Is that still considered same or similar? Issues regarding what happens if the employer goes out of business before the I-140 is approved, or what if you try to port your priority date or port your adjustment of status to the new employer before your I-140 has been approved. So it does mostly clarify what they're looking for in those issues. So that one, I couldn't find anything specifically that's problematic for that. The other one, though, that could be problematic is the use of discretion in adjustment of status applications. That was updated just this week as well. There is a commenting period until January 2nd, but it's actually effective today.
Today, okay.
And it gives officers the power to deny an adjustment of status application, an employment-based adjustment of status application, even if you meet all of the eligibility requirements, which I don't think has ever really been possible before. Usually if you don't meet the eligibility requirements, you can be denied, or you can be denied if you're inadmissible. That's about it. This allows for positive and negative factors that can be used in the discretion to deny your adjustment of status, even if you're not inadmissible and even if you meet all of the eligibility requirements.
Some things that bothered me in this, Emily, is the character that came into picture, though. What I have noticed, one thing is, especially for the people who have DUI, that gets into the character issue, though. Normally, if you have a DUI, we normally tell people, the naturalization applicants, that, hey, this may be an issue. Please delay your application of naturalization until after 5 years that the particular incident happened. Now, of course, there's no 5-year limit for this person, though. Some of these things may affect this person in getting the green card, which was never a trouble for us to get the green card if the person has a DUI. That's one thing that is standing out to me. Whenever there is any policy change, though, or the policy manual change, what I've seen the officer interpreting is that previously, if I recollect, though, okay, Emily, I have not seen a single denial, except one, where a person has moved from company A to company B, and they file the 485J supplement. I have not seen or heard of a single denial single denial of the 485Js, of the 485, because the person changed from company A to company B. The only denial that I have ever seen where a person changed from company A to company B is that this person actually was a software professional, and he is now working as a manager of a restaurant. And the USCIS came to know when he applied for the alcohol license, where he listed that the only profession that he is doing, the only work he is doing as a restaurant manager. That's the only time I've ever seen a denial of the 485 application because the person changed from job. But when I look into this policy manual change right now, even though it is not specific, it doesn't give a lot of, it doesn't tell them to deny the application, I feel that the officers are going to be more vindictive in interpreting the policy manual. So I want people to be very careful when you're filing the 485J supplement. We're going to address this company change in our next part of the discussion, but I just want to alert people that things are changing. Even this administration, while it's going down, they are burning anything what they can possibly do. And this is going to harm us. So I just want everybody to be aware and see whatever precautions that you can take to prevent. It will be much better. Anything else, Emily, before we move on to the next?
I think we can move on.
Emily, now we have a lot of people, especially a good number of people, have filed the adjustment of status application. Now there's a lot of questions coming on the adjustment of status application is that do I maintain the non-immigrant status? Do I go use the EAD? And I want to point out, guys, that we use the word called marriage. Marrying to the adjustment of status. We have defined it before, and we're going to tell you the definition again is that if you use the EAD or if you use an advance parole, that means that you're getting away from your non-immigrant status, then you will be completely dependent on the adjustment of status alone. That is what we consider as marrying to the adjustment of status. If you have an EAD and if you have an advance parole and you still maintain the non-immigrant status and your spouse and children still maintain the non-immigrant status, we consider that you are not yet married to this adjustment of status. You are flirting with adjustment of status, but you are not married to the adjustment of status. Please, I will keep on referring the word marriage all the time. You want to define more about marriage, Emily, before we go?
Yes, one other area where you can end up getting married to your adjustment of status is if you're no longer maintaining your non-immigrant status. So say, for example, you are an F1 student and you have filed the adjustment of status and you decide to stop taking classes. You're no longer maintaining your F1 status. Now you're married to your adjustment of status, even if you're not using that EAD and even if you didn't travel on the advance parole.
So now comes a decision for a lot of people, Emily. Should they maintain the non-immigrant status or should they get married to the adjustment of status? Do you have a one-line answer for them?
No. Well, it depends. That would be my one-line answer.
That's not one-line answer, Emily, for me. It will be to each and every individual that you have to evaluate yourself to see if you want to get married to the adjustment of status. I will point out some of the pluses and some of the minuses for you guys. The one thing that we don't want you to get attached to this 485 application is that I want you to make sure that if you have filed for a downgrade application, we want to make sure that your I-140 is approved before you take a step of getting married to the adjustment of status. That's the number one. The second thing, even though it's not a legal requirement, we strongly recommend that you wait until 180 days is been passed after I-140 has been approved. That's the second thing that I strongly recommend. Now, any other things that you want to discuss? A lot of people ask questions with regards to if you file an adjustment of status, when can you change the company from company A to company B? There are two different scenarios that you will do. One is that if your downgrade application is pending, then it's a different thing. If you are a straight applicant where the downgrade applicant, the I-140 is already approved for the underlying adjustment of status. If your I-140 has been approved and it's been approved for more than 180 days, If you file an adjustment of status, after 180 days, you can change the company from company A to company B. When you change the from company A to company B, you have to file a 485J supplement. In other words, the new company has to fill the 485J supplement, and the new company's job requirements must be similar to the previous company's job requirements. Do they have to be the same? No, they don't have to be the same, but they have to be in the similar profession. So it's better that you evaluate with a lawyer to make sure that the new company job requirement is in a similar profession, and have the new company file a 485J supplement. After 180 days, you file the adjustment of status. You can do so by filing the 485J supplement. This is in case where your downgrade application is not pending. If you have a downgrade application pending, we strongly recommend that you get the I-140 approved first, and you wait for 180 days after the I-140 approval. Plus, you must have already waited for 180 days after your adjustment of status has been filed. So both need to be done, and after that, you can file the 485J supplement. A lot of people ask question, Emily, can we do premium processing if I have already filed the downgrade application?
Well, number one, you have to get the receipt notice.
Okay.
Because you can't file it in premium, but you can upgrade once you have the receipt notice.
So you can't file in premium processing, but you can upgrade to the, and we strongly recommend people to upgrade it to the premium processing once you get a receipt notice.
A couple other questions about premium processing that we've been getting a lot lately is, we had a law that was actually passed by Congress that allows for premium processing for EADs, allows for premium processing for adjustment of status and the EB1C I-140s. What's the status of that? Can I file my adjustment of status in premium processing right now?
First thing is that there is no premium processing for the adjustment of status in the law, but there is an premium processing for the EAD and advanced parole. But even though the law has been passed, the USCIS have to implement that law. They haven't started implementing it. It may take at least 4 to 8 months once they decide to start implementing it. That's the expectation that we're having. Right now, you cannot do a premium processing for EAD or advanced parole, and you cannot do premium processing for a EB1C I-140. But you can still do premium processing right now for the downgrade from EB2 to EB3.
All right, and one other question that comes up quite a bit is with, what makes you eligible to receive this EAD, especially for those that have downgraded? Is it mandatory that their I-140 be approved before USCIS will issue them an EAD?
No, it is not required that your I-140 be approved for you to issue a EAD. We have seen many circumstances, especially under the EB1Cs, where the I-140 is still pending and you still get an EAD and advanced parole approval without subject to whether your I-140 has been approved or not.
All right, and just to confirm, when we're counting 180 days for AC-21, which allows you to move your green card process to your new employer, the I-140, if it's a downgrade, you're saying that should be approved for 180 days before you make the switch, and the 485, 180 days?
One thing I can say is that for the 485, you have to wait for 180 days before you switch. The second condition, whether the I-140 must be approved for more than 180 days, though. Even though it's not a legal condition, Emily, I still feel that there is a chance that the people may get into trouble if the I-140 has not been approved for more than 180 days. I want it as a safety measure, but not a legal requirement that they have to wait for the 180 days.
All right, and no premium processing for the adjustment of status?
No premium processing for adjustment of status. One thing is that previously adjustment of status applications, they didn't used to conduct any interviews. Starting from March of 2017, Trump administration said it's mandatory for all the adjustment of status, including the employment-based adjustment of status, to do the interview though. Although they did mandatory though, recently we have seen the USCIS waiving that condition because of the COVID reasons though. So yeah, most probably this administration might waive it, but at this point of time, we have to assume that they will be interviewed before they get a green card.
All right.
Emily, what about the appointments with the consulates, though? What are you looking at? If I get a H-1B approval right now, when can I go for H-1B stamping?
That's the question of the
I know
year,
there is an
I think.
executive order that is there. That executive order is expiring in December 31st. But what about January 1st? Can I go an appointment with January
Well,
1st?
that order could actually be extended
What are you speaking, Emily?
because Trump
wait,
is still
wait.
president until
So
January.
wait. The executive order banning the employment-based people to come into United States, and also the family preference, which is there in effect until December 31st of 2020. You mean to say he can extend for a 6-month period after that?
Yeah.
But he's going to be only power until January 20th. Can he still do it?
He can still do it, and then it's up to the Biden administration to undo that. But yeah, I would expect
Assuming that he doesn't do that, and assuming that, what about the appointment status, those people who are not applicable in this executive order?
Yeah, even if you're not subject to this executive order, just getting appointment is practically impossible right now. Or if you are able to get one, it's not until February or March, and who knows if they're going to keep those. Consulates have just kind of announced this week that they're slowly resuming normal processing of their normal operations, but that's going to take time, and there's going to be a huge backlog of people waiting that are already outside the U.S. and wanting to get in. So if anyone's in the U.S. now and planning to go for stamping, that's a big risk to take, that you might end up getting stuck waiting for your visa.
Yeah, please be prepared that if you are going outside the country, even though your appointment is scheduled in the month of March, they may not keep the appointment. We have seen the appointments that were being made in October and November. They canceled it. They told people to come make another appointment. So be careful and be watchful for these things. As the things are developing, please come to our hourly immigration updates. Every week we'll keep on updating on what's going on. Let's go to question and answer assembly. Some of the questions, a lot of people ask the question is that, can I get married to this adjustment of status and my wife doesn't get married to this adjustment of status? Or the vice versa though? Yeah, you may do that, but the practical problem is that, do you think so that you will just get the green card and you will ignore your wife? That's not going to happen. I mean, you both want to get the green card. So if one family member gets married to the adjustment of status though, practically speaking about, the entire family is getting married to the adjustment of status. That is, practically speaking, there are some very rare exceptions available. I would recommend that you contact a lawyer to see that if you want to do it. But one person gets married, practically the entire family is going to get married to this application.
Harish from YouTube says that after completing the 180 days for AC-21 and when changing the job, is it okay to change from a programmer position to an IT manager position, for example? Possibly. So that is one thing that is addressed in this new AC-21 policy manual update. They give some various options for career progression, and that's a factor that the officer is going to have to look at. So it does leave the door open for, yes, it could be possible, but again, with these new policy updates, it's more likely that it's going to be used as a sword against you rather than something in favor of you. So they could use that policy update and say, wait, this doesn't meet all of the factors. So there's some risk there.
A lot of questions on with regards to the, would there be a rollback of the wage rules though? We do have a court litigation going on that, and we have to see which way the court is going to decide. If the court does not decide in our favor, the Biden administration cannot just undo it. It may take a little bit longer time for him to undo it. That's number one. Number two is that I'm not sure if Biden administration is in favor of undoing the wage requirement. I don't think so.
Yeah, I think a court may have to step in to help us
Yeah,
on that one.
yeah, I think so that if the court doesn't rule in our favor, we may get stuck with this wage rule forever. Biden administration may not be willing to undo the things. Because remember that, Biden administration is they're more labor protective things rather than business protection. So there is a chance that Biden administration may stick with the rules of the wage rules that are already existing.
Gothami from Facebook wants to know if someone has a valid H-4 visa stamp and entered and later converted to an H-1B through a change of status, is it possible to use the existing H-4 stamp to re-enter the country if we travel outside? Possibly. If you qualify for automatic revalidation, that means if you could travel to Canada or Mexico for less than 30 days and not go for H-1B stamping, you then would be able to re-enter using your H-4 stamp and your H-1B approval notice that has an I-94 number on it. So that is an option. But if you go elsewhere, outside Canada or Mexico, or if you're gone for more than 30 days, or you try to go for H-1B stamping and it gets denied, there's no automatic revalidation for that.
Anjanelu from YouTube has this question. Can I downgrade from EB2 to EB3 without a birth certificate or birth affidavit? First thing is that without birth certificate, yes, you can downgrade from EB2 to EB3, not a problem. You can't get a birth affidavit. I don't see why you can't get a birth certificate. You can't find two friends that can vouch that you're born and they can't give an affidavit. I'll be very surprised to deal with you as a client though. You have to get an affidavit. I don't see any reason. I mean, I've dealt with thousands of clients. You have to get an affidavit. That's so easy to get it. There's no problem in getting a birth affidavit, though. You should get from two separate individuals. I don't see a reason why you cannot get it. Is the travel ban for until December 31st applicable to all H-1Bs? This is a question from Srilata from Facebook. No, it's not applicable to all the H-1Bs. It's those people who are outside the country on June 24th or June 18th, I forgot, June 24th. If you are on H-1B already in United States on June 24th, I may be wrong on that, in the entire month of June, and you have a H-1B, then you are not subject to the executive order though. If you got a H-1B, let's say for example, you're a student visa person and you got a H-1B starting from October 1st, which is when the quota starts, yes, you are subject to the travel ban. But make sure that as Emily has pointed out, that this travel ban is until December 31st, but this administration may extend it. The way we are seeing it is that yes, they most probably will extend the travel ban until 6 months after December 31st of 2020. Of course, the Biden administration can come and undo it. We'll have to see how fast they will undo this one.
Rita from YouTube has applied for an EB3 downgrade with the adjustment of status, EAD, and advanced parole altogether, and wants to know if the I-140 is upgraded to premium processing, can you get the advanced parole any sooner? No, the timing of the I-140 approval has no bearance on the timing of the EAD and AP approval. You're eligible for EAD and AP simply by having a 485 pending, regardless of the I-140. Premium processing really doesn't help you at all, except for giving you the peace of mind that your EB3 downgrade was successful. Other than that, it gives you no benefits.
Joe from YouTube has this question. Is there any regulation that the I-140 has to be paid by an employee? Can you please direct me to the specific regulation? Joe, the regulations doesn't specifically say who should pay. It doesn't say anything. So when it is silent, who can pay? Anybody can pay. When the regulation specifically states that only employer can pay, then the only employer can pay. So it is up to the individual company now to decide whether it's going to be paid by an employer or employee. So that is up to the employer, not to the law. So if the employer says that employee pays for the I-140, then you don't have much option.
Pavan from Facebook wants to know how the wage level is determined for an H-1B. Is it based on experience or the job position description requirements? Ultimately, it is based on the employer's education and experience requirements for that position, job duties, as well as any special skills or supervisory duties that are part of that position. So they determine what is normal for the occupation in terms of years of experience and job duties for that position, and whether you normally will supervise someone as part of those job duties. And then they compare the employer's requirements to what's normal, and anytime something that the employer requires is more than what is normal, the wage level bumps up to a higher level as you add more complexity to the job duties, more years of experience, etc.
A lot of questions are coming with regards to the compelling circumstances EAD that's available for the people who have an I-140 approval. I would recommend that the best lawyer for that is Ryan Vick from our office. You can go to rnlawgroup.com. You can make an appointment with him. He does all these compelling circumstances EAD applications. You can make an appointment and you can speak. His appointments are available even in this week also.
Nag from YouTube wants to know, do you think the filing dates will be moved by October 2021 due to the family immigration ban? Well, generally, the filing date chart does not change throughout the year. So I expect the filing date chart that we have now in November should stay the same in December, January, possibly all the way into June. It may then update later, but it's more the final action date chart that will slowly move to meet where the filing date chart is. And then next October, the filing date chart should jump forward again. How much forward it jumps is going to depend on whether there's any spillover from this year's family-based immigration to next year's employment-based immigration.
Emily, with the travel ban and the COVID situations, what's going on right now, I mean, the year starts from October 1st, so we still have a travel ban for the 2 months period. And even if the travel ban has been lifted, though, we do see a lot of restrictions, especially on the consulates issuing green cards and issuing the visas. There's a lot of delay there. Do you expect some more family preference categories to fall into the category of the employment next year?
I would expect so. I mean, it's about, what did we say, 60,000 family-based green cards a month that are not being issued right now, and that's October, November, December, possibly January, 4 months worth.
Yeah,
I think
October,
that's entirely possible.
October, November, December, and January. So 4 months out of the 12 months is going to be Trump administration. And then we don't know, even if the Biden administration, he's very conservative, especially with regards to the COVID opening up the businesses. So he may not have a ban, but he may restrict on the appointments and people traveling back and forth. Yes, that may lead to have more number of visas available, especially for Indian nationals in the employment-based in the coming year. That means we are speaking about in October of 2021, we may have more numbers available. So if you are been waiting for the green card, and if you have not filed a labor certification, especially when you have moved, this is a time for you to act right now. Because if you are anywhere between 2016 and 2018, I would be very prepared to have file an adjustment of status in October of 2021. Now, having said that, don't believe the dates that we tell with regards to how the priority date movements. Believe us, we went wrong so many times, including in September. We did not predict the dates movement so forward. We went wrong in that. So take your own, think of your own things, but just make sure if I were you, I would prepare myself to have an I-140 and everything ready for me to move on. I mean, one other question that you presented in the previous things is that, what if I have an I-140 approval in the EB2 right now, and I am in the 2016 priority date? Can I now file a downgrade application for EB3 without touching the EB2 application?
Yeah, absolutely. It's really, is your employer willing to do that? And then That way, if you file it now, in the past, we've always told you just wait until the
Right,
priority date is current because
But
you
we
can file.
we don't stand on the same word right now.
Yeah, at this point, assuming we continue to see this same trend where EB3 is advanced from EB2, you may want to consider proactively filing that downgrade if your employer is willing.
What if I file a downgrade application, EB3, and it gets approved? Can I still use the EB2?
Yeah, that's the benefit of not filing this as an amendment. It's a completely separate I-140 petition. You're just using the same labor to qualify for both categories.
A lot of people are asking with regards to the H4 and H4 EAD, when does the premium starts? If the administration wants to implement, it may take anywhere between 4 months to 8 months by the time the premium can start. At this point of time, they have not started implementing it. I can say that the Biden administration, when they come in, they will like to get this premium processing because they like to get the money from us, so they would like to get this premium processing up running pretty soon.
Fanny from Facebook says, do we have to get a new LCA for an H-1B extension if the previous LCA is still valid and has 2 more years left on it? So no, you could use that previous LCA that's been submitted in support of your previous H-1B petition and reuse it to get the remaining 2 years left on it. But of course, then you only get a 2-year extension. So if you want to get a full 3-year extension, then you would need a new LCA for that.
What is the processing? Mudassar Ali is asking, what is the processing time for EB3 if the priority date is current? Well, they're telling anywhere between 16 months to 44 months right now is a processing time. Is that what they are telling, Mudassar? So that's a long period of time, but that's what they're listing it out on the website, and that's what they're doing right now. I have this question from Anik Buyan from Facebook. He is on F1 status, and can he continue on F1 status, but can he use the GCEAD to work? I'm assuming that you are the child and you're a beneficiary of the adjustment of status. Most probably that's the reason. No, once you use the GCEAD to work, your F1 is automatically invalid. So you will lose that status, and once you work, you are considered to be married to this adjustment of status application. So that is a short form. And a lot of
what are the downsides of being married to this adjustment of status?
One thing is that, especially I'm worried about Anik, is that if he is 20 years old, if he gets married to the adjustment of status though, then if the priority date is not current, final action date is current, then he will not be able to maintain the F1, he has to leave the country. That's the main thing that I have. If there is no fear for the people I mean, if they're not children who are becoming 21, if they're regular wife and husband though, yeah, I mean, I don't know why people don't want to get married to this adjustment of status. I would like to get married to this adjustment of status. As long as the I-140 is approved, Emily, I would like to get married to this adjustment of status. I don't know why people are hesitating getting married to the adjustment of status. Maintaining 2 statuses is not that easy. You're maintaining the adjustment of status, you're maintaining the H1 and H4, and especially we have delays in the H4 EAD right now, a long delays, up to 20 months, and then we have the wages that went up. Now we have the specialty occupation and consulting that is coming up. I'm not sure if I have the I-140 approved, I would like to get married to the adjustment of status. But that's each individual preference though.
Yeah, another consideration is if it was a downgrade.
Right,
case.
especially.
If you do get married, then you're stuck in EB3. It's not easy to go back to EB2 after you've already been
married to the adjustment of status. But I'm still fine with getting married even after once the I-140 is approved, Emily. But if if you're considering to let the H-1B go though, there are a lot of individual circumstances that may prevail. Maybe you have a DUI, maybe a lot of different circumstances. I would recommend that you have a consultation with a lawyer and sit down with a lawyer and see, what all the things that you can think about negatively if you get married to this adjustment of status. And what are the advantages and what are the disadvantages of getting married to the adjustment? The major advantage in getting married to the adjustment of status is that you don't have to apply for H1 extension so frequently. I mean, you don't have to file for the H-1B extension or H-4. You are not subject to the new wage rules. You're not subject to the new regulations that are becoming effective on December 8th. And you will be more freedom to move from company A to company B by filing a 485J supplement. And believe me, one thing, 485J supplement is 10 times easier than H-1B, especially with the December 8th regulations going on, end client, vendor, a lot of different things are there. Prevailing wage have to be met, LCA has to be approved. With all those things, and then premium processing you have to do the premium processing, which is $2,500. The filing fees there's a lot of expenditures, a lot of paperwork to maintain the H-1B. But if you were to go to the 485J supplement, do you guys know what is the fees if you change from company A to company B after 180 days to file a 485J supplement? Let me tell you one thing, the fees is $0. So that's how easy to move from one company to another company if you are in adjustment of status. But if you're in H-1B, it's a lot of expenditure and good money for a lot of lawyers like me and Emily.
Navaneeth from YouTube wants to know if he can renew his parents' visitor visa more than once. They already renewed it, haven't heard back from USCIS, but they're still stuck here because of COVID. Well, in that situation, you really don't have a choice. If they cannot leave by the date of the extension that they previously requested, they have to file another one. We're in kind of uncharted waters here, where prior to 2020, I would have never told someone to file more than one B2 extension.
Except in the medical extreme emergency assembly, yeah.
Yeah, but now we're in a new uncharted waters, and so I think that's your only choice if they can't leave by that date.
Going through the advantages of getting married to the adjustment of status, one other thing that I want to point out that even though the first EAD that you're filing will take a long time for you to get it, the second extension of EAD you can file 6 months in advance, and if you don't receive an EAD approval, you can still continue working for a period of 180 days while the EAD extension is pending. Now this is only for the adjustment of status EAD, not for the H-4 EAD. Please don't mistake my words for the H-4 EAD.
Karthik from YouTube wanted more information about that use of discretion policy manual update for adjustment of status. So basically, I'll go through kind of what the factors are that USCIS is going to look to. In the past, they would just look at, do you meet all of the eligibility requirements, or is there something that makes you inadmissible? Now, they just describe as a positive factor if you have family ties in the United States, if it would cause hardship to those relatives if your adjustment of status was denied, the length of time you've lived in the U.S., your compliance with immigration laws, if you have property here, invested here, business ties here, employment history in the U.S., your education and skills are positive factors, your respect for law and order, compliance with tax laws, and any kind of criminal issues are looked at negatively. Other negative factors are absence of family ties, absence of a long residence history here, violation of immigration laws, unauthorized employment, a history of unemployment, failure to file your taxes, failure to pay child support. Those are the things that count for or against you that they could ultimately use to deny your adjustment of status, even though you meet all the legal requirements.
I mean, this is a big drama this Trump administration created only to confuse and extend the time of adjudication of the adjustment of status. This is just another way of harassing the immigrants. More questions on the priority date movements. What do you expect the priority date if you're in July 2016? This is a question on Sanjeev. Yeah, I would be ready to file an adjustment of status, especially in October 2021. Be prepared, but we can go wrong. I mean, we have gone wrong many times. But if I were you, I would be prepared for everything and then be ready to file adjustment of status in October of 2021. Could it be that it will be before October 2021? That's very unlikely, but hopefully we go wrong on that again. That will be very good for you.
Anil from YouTube has recently filed a premium H-1B extension and wants to know if the decision comes after December 8th, will it be a 3-year approval or a 1-year approval? So assuming this is a third-party placement situation, the good news is for pending extensions, they do not apply the new rule. It's only if the application is filed after December 8th. So since yours was filed before December 8th, the old rule still applies.
Rajesh has this question. Once I and my wife get advance parole, can I be on H1 while my wife use advance parole? Well, that means, Rakesh, your wife is married to the adjustment of status. We have commented over before whether or not you're willing to get the green card. If by any chance some problem occurred, will you be willing to get a green card without your wife? That's what you have to decide on. Satish has this question, a very good question, Emily. But I want to give the percentages of chances of denial too here. What he's asking, Satish from YouTube, is that once we are married to the adjustment of status, what are the chances of getting the 485 denied? First thing is, I want you to answer the question, Emily, is that how many times do you see, how much percentage of the cases do you see 485 getting denied?
At most 5 a year.
No, percentage-wise.
Percentage-wise, less than 1%?
Less than 1% of the chances are the reason why 485 gets denied. And what are the common reasons for getting a denial?
I would say the most common is I-140 denial.
I-140 denial. If the underlying I-140 gets denied or revoked, though, that's the major thing that we look into where the 485 gets denied. That's the number one reason that we see the 485 getting denied. The second reason is that if there is a period of unemployment after filing the adjustment of status, that may be a cause for trouble. Third reason is that if there is any, and I would probably go this one as second reason, or the third reason is that if there is any criminal history, especially domestic violence, certain things that may affect you, a domestic violence crime that may affect you. With the new policy memorandum right now, I would say that if you have a DUI though, because they said it's a character of it, that may be a factor. It wasn't a factor before though, but I'm thinking that it may become a factor. Especially if there's a crime, that may be a factor. As Emily pointed out though, that it is less than 1% of the time we see the 485 cases get denied. And I mean, we cite out the main reason. Number one is the I-140. The number two is the crime. The number three would be that if there is an unemployment of you where you don't have any employment. These are the three reasons that we can think about. Can you think of anything else?
Anything else would be maybe failure to maintain status at the time of filing.
Okay.
Or unauthorized employment for more than 180 days. I think those are about.
Yeah, but still we are falling within 1% of the things. And even if with the interpretation of the law right now, especially the DUI, we may expect that may be 2% to 3%, but not more than 97% you should be clean in getting the adjustment of status though. So that's a reason where I normally tend towards leaning towards getting married to the adjustment of status as compared to maintaining. One of the other problem is when you maintain two statuses though, there's another problem that raises a question, which many people are not aware of that. Now we did cite it that saying that there's 1 to 2% chance if you get married to the adjustment of status, you'll be at risk in getting the adjustment of status denied. But there is also another problem. If you don't get married to the adjustment of status, if you keep maintaining the H-1B and H-4, especially when the H-1B extension gets denied though, guess what happens though? That denial will be considered by the adjustment of status application though. The officer who's adjudicating the adjustment of status will look into it. Well, they denied the H-1B, why should I approve the adjustment of status? That risk is much higher though, but people don't realize that. But I just want to point out that to you, that if you get married, the chances will be very less. If you don't get married, the chances will be very higher risk for you to getting denied of the 485.
Suyash from Facebook wants to know, for H4 kids who are aging out, can they file an F1 if they've also filed the 485 already, but the final action date is not current yet? That's going to be a very common question that's happening. Again, we're kind of into a new phase where so many people have been able to file, but are also likely to age out because the processing times are going to be long and the final action date really isn't current. You know, the rule is F1s have to have non-immigrant intent. It does not allow for dual intent. So when they file that change of status application, the I-539 application specifically asks, have you ever filed an immigrant petition or adjustment of status? You do have to disclose it. Will they deny for that? Remains to be seen.
Yeah, previously though, we haven't seen much denials based on that reason though. Emily, I have seen only one RFE recently saying that are you maintaining the status out of the country? But under the general scenario, whether or not you are going to get an approval of the I-539 F1 status though, we strongly recommend file it. If you get the denial, so be it. But we should recommend them to file it, because we don't want you to get married to the adjustment of status until the final action date is current, and by that time you are under 21, legally speaking about you're under 21, then you're fine to get married to the adjustment of status. But children, especially if they are between 16 and 21, we strongly recommend that they should move on from H4 to the F1. They should apply for it. Unless the final action date becomes current, then it may be safe for them to get married to the adjustment of status. Otherwise, we want them to move to the F1 status.
Suri from Facebook wants to know if we've received any receipt notices for the EB3 downgrade cases. No, we have not, and that's normal right now.
But the reason is that, Emily, we filed most of them in the last 2 weeks of the October, though. We didn't file in the first 3 weeks of October, we didn't file it.
Right, and the other thing with downgrades, they all go to the same lockbox.
Texas Service Center.
The entire country's downgrades went to one place. So you can imagine that that's going to be a large number of cases for them to go through. So that's normal that we haven't received those receipt notices yet. Checks have not been cashed yet. But once you do have that receipt, you should be eligible for a downgrade, for a premium processing. I don't think we've ever had a problem with upgrading to premium on a downgrade.
We didn't have any problem in upgrading to premium processing once the downgrade application was being filed, once we received the receipt notices. What we noticed is that, though, I think so before 2015, Emily, I did have some problems with the downgrade application where I sent for the premium processing. But since 2015, seems that some database things have changed in immigration, so we haven't seen much problem, none at all actually, none at all. All the downgrade applications, they took our money and they adjudicated the cases in the proper timing. How long, Garcia from YouTube has a question, how long it will take for L1A person to get the green card? Assuming your employer is willing to file an application, it may take anywhere between, I'm assuming that you're not from India. If you're not from India, it may take anywhere between 1.5 years to about 3.5 years for you to get the green card, if your employer is willing to file an application for I-140 adjustment of status. If everything goes good, between 1.5 years to 3.5 years is when you get the green card. Anything else, Emily?
Let's see. A couple of questions again on when premium processing will be available for the H4 and H4 EAD. Don't expect it to be in the near future, so if you have an application pending right now, it's not going to be available to help your current application, but possibly next time you need to file an extension.
Prevailing wage for San Francisco Bay Area level 3. Wow, that's going to be very high. I would say, I can't imagine, but it'll be more than 120,000, especially in the San Francisco Bay Area.
It actually doesn't have data.
Oh, really? San Francisco area?
One of the Bay Area locations for software developer, no data at all.
Okay, when it comes, it will be very high. People who have issues with the prevailing wage thing, there are alternative wages that you can look into it. Most of the lawyers are aware of these alternative wages. But if ever you want to consult a lawyer, you can also avail our services. Try to book an appointment not with me and Emily. You have H-1B lawyers that deal in the prevailing wage day in and day out. So you can go to RN Law Group and make an appointment at any time to speak with any of our H-1B lawyers.
All right, I think that's about it for today.
Thank you guys for tuning in. Don't forget that you can make an appointment with me or Emily or any of our colleagues at rnlawgroup.com. Don't forget to subscribe rnlawgroup.com's newsletter and also Emily's blog at immigrationgirl.com.